Hi, everyone. Carl Steinbeck here. Sunday night. Just wanted to cover day 17. I thought I'd be doing that Friday night, but had a busy day Friday, so I didn't get around to it. And so anyway, it was somewhat a upsetting time also to see again the prosecution just has everything always perfectly aligned for the judge to always rule in their favor almost every single time, especially of things that are very substantive and affect the constitutional rights of Karen Reed. So, anyway, it wasn't surprising from that standpoint. I think we all realized how that was going to go down. So we'll talk about that a little bit later. But I can say that the let's first get into this beginning part here because it's sort of the beginning of Friday, sort of like fed along the lines of what I'm thinking this jury is about. So stand by here.
Beverly Canoni, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Good morning again, counsel. Good morning again, Ms. Reed. Good morning, jurors. So I appreciate your patience. I have to ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left yesterday?
Yes.
Everyone said yes and nodded affirmatively. Were you also able to follow my instructions and refrain from doing any independent research or investigation into this case?
Yes.
Everyone said yes and nodded affirmatively. Did anyone happen to see, hear, or read?
Okay, right there. I'm just thinking, the judge, how could she see 18 people's responses? If they're all nodding, you have to look up and down. There's a couple rows of jurors, and you also have to see some kind of audible response. So she's saying she's seen, confirms both are in effect for all 18. So how's that even possible?
Anything about this case since we left yesterday? I have one other important.
So how has 18 people for over 3.5 weeks not heard anything about this case come up in any conversation anywhere they've time they've left the courthouse? So, this whole thing is fitting into my theory that jurors, they all look at what's going on in social media, on web search and stuff like that, and they're not going to admit it. So that's something I think is going to ultimately help the defense because of the roadblocking of the truth that the prosecution is doing and that the judge is rubber stamping. So
instruction for you folks, and it's so important that each and every juror can hear the evidence or the testimony that's presented, can follow the testimony, and can understand and evaluate the testimony of each witness and the exhibits. In order to do that, I just want to be very clear that it's important that people do not comment on the evidence or make any comments. Once you enter the room, it's probably a good idea to just listen. Don't talk, don't make any facial expressions, no muttering under your breath, no audible noises, because people need to hear what's going on and to understand everything. So out of respect for your fellow jurors, I would ask that you be very careful to make sure you don't do that. And out of respect to the lawyers who worked so hard to get this case before.
Okay, this translates to the jury's already sick of what's going on here. The jury's already tired of all the antics of the prosecutor. The jury doesn't like this judge basically in the hip pocket of the prosecutor, rubber stamping everything that's going on, sustaining all of their objections and overruling the defenses. So it's really what I think is I've never seen a prosecutor this out of control and this sneaky about the way he's doing stuff. And he also has an extremely unlikable personality in court. And then you have the judge that this seems to be totally on his side as a second prosecutor of sorts. And so this is not going to play well with the jury. And exactly what's happened is we've also heard that a juror went to one of the bailiffs and said, can we actually hear what's the truth of the answer instead of these objections always coming forward. So supposedly that came out a couple of days ago. Some reporter, Howie Carr, was saying that this was like reported to him secondhand or something. So I don't know the truth of it, but I'm telling you, from my experience working many jury trials, you cannot just act any way you want. You cannot just act like you want to just object to everything all the time and just hamstring the other side and try to block the really, really good questions from coming out, which show whether Karen Reed has, is really guilty or innocent. So anything that's truthful, it's like they're blocking. And I think the jury knows enough about the case. They're getting sick of it. Maybe not every single one of them, but enough of them are getting sick of this dog and pony show, this goat rodeo that's really hampering the truth from coming out. So it's not even under the guise of a court of law anymore. It's really under the guise of let's cherry pick the evidence we want to come in, and anything that could explain how other people might have been involved in John O'Keefe's death. That information is not relevant. It's going to confuse the jury. So the only thing they want is evidence that points a finger at Karen Reed. They don't want any other evidence that comes out and points a finger at anybody else or raises reasonable doubts about how they collected the evidence that they're then using to try to say, let's see, this points a finger at Karen Reed. So everything is a convoluted, hot mess. And the judges even making excuses for when they have chain of custody that's absolutely broken. So you just don't see stuff this insane, crazy in a court of law in any case I've ever seen in different parts of the United States. So that's what I think is going on here. You cannot act this way like Hank Brennan and expect the jury to like you and want to support and do what you're asking them to do, which is convict Karen Reed. So I think all these things that are working against Karen Reed by all these truths not coming out, I think the jury, for the most part, sees it for what it is, which is when Hank is objecting to something, the jury's picking up that it's the truth. He's blocking the truth. And if you block the truth as a prosecutor, you pretty much are telling the jury your case is absolutely garbage. You can't win the case other than just to hamstring the defense or bringing out the truth. So that's what I think we're going to get more of
Thank
here.
you very much. With that, Mr. Brennan, your first witness, please.
I've never seen a juror complain about the behavior of the judge and the prosecutor. I've never heard of that. Okay. But that's how bad this disaster is here on an ongoing basis. Can you imagine being away over 3.5 weeks, 4 weeks, and you're not maybe halfway done with this trial, and they're wasting all your time and blocking really good, legitimate questions from coming forward?
Or if I could begin by offering a stipulation that's
the jury's basically being hijacked, and in a way, they're sort of like under some kind of bailment here. They can't bail themselves out of the situation because they want to know both sides. They want to hear the truth. But if you got one side constantly blocking the truth and not respecting their time and their interest in a legitimate question, then you pretty much are really not doing your job as a lawyer, and you're not doing you're not doing anything to gain yourself credibility with the jury. And if you don't have credibility, you have a huge likelihood of losing your case, even if you got a strong case, which the prosecution doesn't have, by the way.
agreed to between the parties.
Okay, can we turn the AC down, please? Thank you. Yes.
Your Honor, if I may, I'd like to read a stipulation agreement between the Commonwealth and the defense.
Okay.
And the stipulation between the parties is as follows. Now comes the Commonwealth and Karen Reed, the defendant, in the above captioned matter. Both parties respectfully stipulate to the following.
That's how I understand what's happening. Like even back to Sergeant Buchanan, the jurors were just shaking their head, like laughing, like, you got to be kidding. He expects us to believe that kind of lying.
The two Massachusetts State Police troopers present at the autopsy conducted by the medical examiner, Dr. Scortibello, on January 31st, 2022, were Trooper Keefe and Trooper Watson. Former Trooper Michael Proctor was not present.
Tonight,
Right.
Both parties respectfully stipulate to the following. the two Massachusetts State Police troopers present at the
Wrong.
autopsy
Sorry.
conducted by the medical examiner.
Okay, I don't know why defense would stipulate to that, because initially I thought it wasn't Proctor, but then looking at it closer, and I did think it could be him. And there's some talk on the internet that this is on this actual slide itself. It talks about Proctor and Keefe there at the autopsy, or at least it says A for autopsy. So I'm thinking it might be him. So I don't know why. I'd make defense prove that Keefe wasn't telling the truth and that Proctor wasn't there.
Thank you.
And with-
Yes, thank you.
with that, Your Honor, I'd like to introduce and play clip number 21.
Okay, Paul, turn the AC off. Hold on 1 second, please, I just want that. Can the jurors hear better with that on?
So John's laying there on his left and his right, and I approached John from the left. That's where the street is. And he had a piece of glass, like perched on his nose, like just wedged like a splinter would be. And I just pulled it, and as soon as I pulled it, it just gushed blood down his face.
All right, looks like Karen's being attentive to him and trying to help clean up his face and get that piece of glass out of his nose. And if blood is gushing out, what does that tell you? He was still alive. So he's that close to being alive. And if they would have taken Karen over there right away, maybe it would have made the difference. Could have saved his life instead of doing this wild goose chase that took almost an hour before they got to 34 Fairview.
So we need this marked.
Yes. We have the item.
Exhibit 169.
Mr. Lally, you're next.
Your Honor, the Commonwealth calls Andre Porto to the stand.
He's one of the lab guys, Andre Porto, forensic scientist.
Morning. Hey, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, sir.
Morning.
Could you please introduce yourself to the jury, spelling your last name for the court?
Yeah, my name is Andre Porto, last name spelled Porto.
And what do you do for work, sir?
I'm a forensic scientist too in the DNA unit at the Massachusetts State Police Crime Lab.
And where did you go to school?
I received my undergraduate Bachelor of Science in Microbiology from the University of Massachusetts in Amherst. And then I received a Master of Science in Biomedical Forensic Sciences at the Boston University School of Medicine.
Now, following your education, where did you go to work?
I started at the Massachusetts State Police Crime Lab in the DNA unit.
And how long have you worked at?
Up ahead here.
Now, Mr. Porto, are there steps taken in your lab during that process that you were just explaining to prevent against contamination?
Yes, there are.
And can you explain what those are?
Sure. So there are various steps. One step to prevent contamination between analysts would be to bleach and wipe down the workstations before use. And
Yeah, let's jump ahead.
Now, in your work at the lab, do you have something that's referred to as a known item?
yes,
And can you explain to the jury what a known item is?
sure. So a known item is an item that's taken directly from a person to be used as a reference sample, so we know what the source of that profile is.
And conversely, what is a questioned item?
A questioned item is an item that's taken, let's say, from a crime scene where we don't know what the source is.
Now, do you also have terminology within your lab as far as a parent versus a child item?
Yes, we do.
And can you explain Can you explain how those labels are and how they reference to what you do in your work?
Sure. So a parent item is, for example, the original item, and the child is a sample of that item. So, for example, this box of tissues.
Marlo, thank you. Please give your money instead to the Reed Defense Fund. And yeah, I do believe the judge is too involved in picking the jury, and all it takes is one to cause a mistrial. So yeah, that it would be a worst case scenario is a mistrial, but there's no way they're going to get 12 people to agree that the prosecution has proved their case beyond a reasonable doubt.
Would be the parent item, and if you were to swab the outside, the swab would be the child item. So the box of tissues would receive, let's say, an item of 1-1. The swabbing of the outside would receive an item of 1-1.1.
Now, what are positive and negative controls?
Yeah, so a positive control is a control that has it's a known sample with a known DNA profile that we use in every step of the DNA analysis process to make sure that each step and instrument worked as expected and properly. And then a negative control is a sample that has no DNA in it. It only receives the chemicals that we use. And that's to ensure that the chemicals that we're using don't have any DNA inherent to them.
Now, when you as an analyst or a forensic scientist too are assigned work within the DNA unit, where do you retrieve that evidence from?
Yeah, so I retrieve it from a locked cold room that's only accessible via keycard.
Now, why are items kept in cold storage?
Yeah, the cold storage helps preserve the DNA for long-term storage.
And as far as the heat versus the cold, what exactly is a DNA profile?
Yeah, so a DNA genes.
And is there any further indication as to whom those genes belong to?
John O'Keefe.
Now, were you also able to generate a DNA profile from this item, the stain A on the upper right leg of Mr. O'Keefe's genes?
Yes, I was.
And from your comparative analysis from the question item to that of the known standard of John O'Keefe, what did you conclude?
Correct.
Now, was that item also submitted to an outside vendor named Bodhi Technologies for further analysis?
Correct.
And with reference to your comparative analysis from the profile from this item to Mr. O'Keefe profile, if you could again just expound upon what does inclusion mean?
Yes, so an inclusion, I compared the known standard that I had available for use from John O'Keefe to the DNA profile generated from the tail light. And the DNA profile if that was consistent with the DNA profile that I observed in the questioned item, and that's what an inclusion means.
All right, so just to move this along here, so this Porto said that for the passenger taillight of Karen's Lexus, there was 3 contributors, DNA from John O'Keefe and 2 unknown individuals. Then they tested the root end of the hair extracted from the passenger side of the rear panel. No DNA detected. Sample was then sent to the Bodhi lab.
Now, regarding item 3-6, what is the description of that item?
Yeah, so 3-6 is a root end of hair from exterior passenger side rear panel.
And is that the same vehicle as far as the taillight sample?
Correct.
Now, with respect to hair in general, there's a root end and a shaft end, correct?
Correct.
And what limitations does your lab have with regard to DNA testing of hair?
So when we test hair, we're actually, the root end of the hair, we're looking at any potential skin cells that might be attached to the root end. So that's where the DNA that we're looking for is coming from. And if there's not too many, yeah.
Now, are you familiar with the term based on your training experience known as autosomal DNA?
Yes.
And can you describe for the jury what your understanding of that term is?
Yeah, so autosomal DNA is DNA that's located in the nucleus of the cell, and that's the DNA that we inherit from both mom and dad.
Now, are you also familiar, based on your training experience, with a term known as mitochondrial DNA?
Yes.
And can you please explain to the jury what your understanding of the term mitochondrial DNA is?
Yeah, so mitochondrial DNA is DNA that's found in the mitochondria of a cell, and we inherit that from the mother.
It may be somewhat evident, but could you please explain to the jury sort of the difference between autosomal DNA on the one hand and mitochondrial DNA on the other?
Yeah, so like I said, the autosomal DNA is the one that we have 2 copies of, where we inherit one from mom and one from dad. And then the mitochondrial DNA is a circular DNA that we just inherit from mom.
Now, is the Massachusetts State Police Crime Lab equipped to perform mitochondrial DNA testing?
No, we're not.
Now, was the DNA extract from the hair also sent to that external vendor, Bodie Technologies in Lorton, Virginia?
I'm not sure if the extract was sent, but I know that the shaft of the hair was sent to Bodie.
Now, what testing did you perform on the hair?
I did the regular DNA analysis process on the root end of the hair.
And that was done prior to it being shipped to that external vendor, is that correct?
Correct.
And what conclusions were you able to draw from the testing that you did on the hair?
Yeah, so there was no human DNA detected and STR analysis was not performed.
Now, what does that mean, sir?
Jam, can I explain the basis for disline questions about alternate theories of the case? That is so extremely prejudicial to the defense theory to not be able to explore other things such as dog bite or being hit in the head with a barbell, a bat, etc. To not be able to question a medical examiner about that is just so far off in left field from what should be happening here in a trial in the United States. So Massachusetts is totally different. And is this exclusive to Karen Reed that they trample on defendants' rights this much? I just noticed that the judge never cites any U.S. Supreme Court case law or any federal decisions in her opinions. It's always these really bizarre Massachusetts decisions, which are extremely, I think, in violation of the Constitution, many of them. So it's just a whole different world up there. All right, where'd I go now here?
We proceed to step 3, which is called amplification. And that's basically, think of it as a molecular photocopier to be used as a reference sample so we know what the source of that profile is.
And conversely, what is a questioned item?
A questioned item is an item that's taken, let's say, from a crime scene where we don't know what the source is.
Now, do you also have terminology within your lab as far as a parent versus a child item?
Yes, we do.
And can you explain how those labels are and how they reference to what you do in your work?
Sure. So a parent item is, for example, the original item, and the child is a sample of that item. So, for example, this box of tissues would be the parent item, and if you were to swab the outside, the swab would be the child item. So the box of tissues would receive, let's say, an item of 1-1. The swabbing of the outside would receive an item of 1-1.1.
Now, what are positive and negative controls?
Yeah, so a positive control is a control that has it's a known sample with a known DNA profile that we use in every step of the DNA analysis process to make sure that each step and instrument worked as expected and properly. And then a negative control is a sample that has no DNA in it. It only receives the chemicals that we use. And that,
yeah, I'm worried about that. That juror that sent that complaint through the bailiff, what are the odds that person is going to make it to the final 12?
that's to ensure that the chemicals that we're using don't have any DNA inherent to them.
Now, when you as an analyst or a forensic scientist too are assigned work within the DNA unit, where do you retrieve that evidence from?
Yeah, so I retrieve it from a locked cold room that's only accessible via keycard.
Now, why are items kept in cold storage?
Yeah, the cold storage helps preserve the DNA for long-term storage.
And as far as the heat versus the cold, why is it that it's specifically kept, or why does the coldness of the storage room help preserve the item?
The cold can help prevent, let's say, growth of bacteria and mold that can degrade DNA.
And what does heat do conversely in reference to an item of forensic value?
Heat can help degrade DNA and also promotes bacterial and mold growth that can further degrade that DNA.
Now, when you receive an item from the cold storage, how is that item typically packaged when you retrieve it from there?
Sure. So the item comes in these plastic, clear, transparent plastic sealed containers that has a label with a case number on it. And inside of that, each sample is within like a small plastic tube that has a label with a case number and item number.
Now, at some point, were you assigned to perform some work on a lab case number 22-02184 pertaining to this defendant, Karen Reed?
Yes, I did.
And what type of work in general terms were you assigned to do in this case?
I was assigned to do the DNA analysis process.
And that was on several items, is that correct?
Correct.
And could you explain to the jury the sort of the process that you used to analyze evidence? And can you describe for the jury what your understanding of that term is?
Yeah, so autosomal DNA is DNA that's located in the nucleus of the cell, and that's the DNA that we inherit from both mom and dad.
All right, this is something we can spend too much time on. So I'm just going to go through all the different DNA items that we have here from what this witness from the state of Massachusetts is stating. Keep in mind the chain of custody was completely botched. They have no legitimate chain of custody, so take that into account. But as I mentioned, we have the passenger tail light, the supposed hair that is not, they can't even prove it's hair that was on the passenger side rear panel, which seems so preposterous that any hair could survive a 60-mile trip through wind-whipped freezing temperatures. And then we also have a stain A on the upper right leg of John's jeans. There's 3 contributors and 2 unknown individuals besides John. And then the stain B also on the upper right leg of his jeans. Same thing, DNA from John and 2 unknown individuals. Then we also have stain C on the upper right leg as well. 2 contributors, 1 John and another individual. Then they also tested stain D on the upper right leg of John's jeans. 3 contributors, DNA from John O'Keefe and 2 unknown individuals. They also, there's a stain E on the upper right leg. So all these are upper right leg of John's jeans. 2 contributors, 1 from John and 1 unknown. They also tested a sample from an unstained area of John's jeans. There was 4 contributors there, DNA from John and 3 unknown individuals. Then they also tested stain C on top of the gray long sleeve shirt that he was wearing. There's just John as a contributor for that. There's also a stain L on the back bottom of the long sleeve t-shirt or long sleeve shirt. 2 contributors, 1 from John and another one from an unknown individual. Then they also tested a sample from an various other samples had profiles generated, but none were suitable for comparison. Either too many contributors, apparently, or from the shoe, or too little DNA. They also took fingernail clippings from John in his left hand and right hand. Both showed that was his DNA. So what they didn't do was try to find out and ask other folks to do DNA test swabs from. So for example, the people in the house, they never did any DNA swab requests for them. So this is a big blunder by the Massachusetts State Police. Wouldn't they want to find out whose DNA that is on John's body? I mean, that would help show that there's maybe something that was going on that is not accurate according to the government's narrative. But if they don't test it, then they don't have to deal with things that don't fit their narrative. So this is like exculpatory for the defense potentially, and they don't want to rule that in or out. So to me, this looks very suspicious. And let's go to the cross here. This guy's testimony didn't last that long. Here at 109.
Thank you, sir. I have nothing further on. Mayor, Your Honor?
Yes.
Good morning, sir.
Good morning.
Mr. Porto, I would like to start by asking you about item 3-1.1, which you've identified as a sample from the passenger side taillight of the vehicle. Can you orient yourself in your report to that item?
Yes.
And that, of course, was the passenger side taillight that was attached to the vehicle, correct?
Correct.
You were never asked to do any DNA comparison on any pieces of taillight connected with this case, correct?
Let me check my other report. For taillight, there was another item that was item 2-3.1, which is sampled from apparent glass on rear bumper, if that's what you're referencing.
Okay, so if I suggested to you that the taillight was plastic, that glass wouldn't have been the taillight, correct?
I don't have, that's beyond my scope of testing.
Gotcha. Okay. With regard to the passenger side taillight, you found that there were 3 contributors of DNA to that taillight attached to the vehicle, correct?
Correct.
One of those contributors appeared to be John O'Keefe. Is that fair to say?
He was included
All
into
right.
the profile.
With regard to the other 2 contributors, who were they?
They could be anybody.
Including people in the house.
Were you ever asked to compare DNA samples from either Canton Police Detective Kevin Albert or Canton Police Chief Kenneth Berkowitz to the DNA profile that you analyzed from that passenger side taillight?
I was not.
Now, with regard to the broken drinking glass, which is item 3-2.1.1, do you see that in your report?
I do.
With regard to that, you came up with a DNA profile that also had 3 contributors, correct?
Correct.
One of those contributors appeared to be John O'Keefe, correct?
He was included, correct.
Who were the other 2 contributors?
I don't know. They could be anybody.
Were you ever
Keep in mind, it's not his job to decide who to test. He's just given the samples to do the testing and run them through the machine and get the results. So this is something that Proctor and other folks like his boss, Sergeant Buchanan, should have been doing all along to rule out any possible suspects for this. They saw that the evidence there was not aligning properly. They couldn't find these pieces, and they show up days later, mysteriously showing up days later. So something's very fishy. All these people in the house getting lawyers and all these butt dials, stuff like that. So if they didn't initially think this was possible defense theory, once they got the FBI data dump, then they should have really realized, hey, this is not looking like we thought it was. We need to do some further testing. But it's never done because it doesn't fit the narrative. They could have this blow up in their face if they did that testing.
asked with regard to that broken drinking glass to compare the DNA profile that you analyzed with the DNA of either Boston Police Sergeant Brian Albert or ATF agent Brian Higgins?
I was not.
Now, with regard to 7.
Yeah, social. You're saying you think he was jumped in the garage. He sucker punched by Higgins, fell back, struck his head. After that, panic set in. So yeah, but they never went in the house, never went in the garage or the breezeway connecting the 2. So they had a chance to get DNA then and really find out the truth of the matter. But because they never asked for consent to search the house, never asked to get a search warrant from a judge, this whole thing
1.2.1
blundered from the get-go.
or maybe it's 7-1.2.1. That's the stain A from the upper right leg of the jeans.
Correct.
All right. And you were aware, you were told that those were the jeans that John O'Keefe was wearing on the morning in question when he was found?
Based on the sample description, that's what it seems.
All right. And it turned out that his DNA was on his own jeans, correct?
He was included in the profile
All
from
right.
that
And
item.
that was unsurprising to you, correct? And with regard to that item, you found that there were 3 contributors of DNA, correct?
Correct.
With John O'Keefe being one of them.
He was included in the profile, yes.
And who were the other 2?
I don't know. They could be anybody.
Let's move on to stain B, also from the upper right leg of the jeans. That is 7-1.3.1. You see that in your report.
I do.
When you found a DNA profile, how many contributors of DNA were there?
3 contributors.
All right. And again, this was John O'Keefe's jeans, correct?
Based on the description, yes.
So he was one of the 3 contributors.
He was included in the profile, yeah.
Who were the other 2?
I don't know. They could be anybody.
Moving on to stain C from the upper right leg of the jeans, 7-1.4.1. You see that in your report?
I do.
With regard to the DNA profile that you analyzed there, how many contributors of DNA were there to that profile?
At least 2, and it was interpreted as 2 contributors.
And again, this is the same pair of jeans that he was found in, correct?
Based on the description, yes.
And you said at least 2 contributors. It actually could have been more than 2.
Based on our protocols, I had to call it 2, and we determined it as 2, but it could be more than 2, yes.
I'll get to this here later in the live stream here.
Okay. Well,
Just-
let's pay attention to the one that was not John O'Keefe, at least that one. Who contributed that DNA to his pants?
I don't know. It could be anybody.
Moving on to stain D, which is 7-1.5.1. And if I can just put my glasses on to make sure I've read my own writing correctly. Actually, is it 7-15-1? Did I get that wrong the first time?
D?
I'm sorry?
Do you mean
Stain D. Stain D.
Stain D is 7-1.5.1.
Oh, I had it right the first time. Okay. With regard to that stain, you also got a DNA profile. And how many contributors were there to that DNA profile?
I interpret it as 3 contributors.
And again, this is John O'Keefe's genes, correct?
Correct.
He was one of the contributors to his own genes, correct?
He was included in the profile.
And
correct.
with regard to that stain on the upper right leg of his jeans, who contributed the DNA to who were the other 2 contributors of DNA to that stain?
I don't know. They could be anybody.
And then finally, with regard to that upper right leg of the jeans, there was also a stain E, correct?
Correct.
How many contributors did you find to that DNA profile?
2 contributors.
One of which was John O'Keefe to his own genes, correct?
He was included, yes.
And who was the other contributor to that stain on the jeans?
It could be anybody. I don't know.
And by the way, just for the record, that was 7.1.6.1?
7-1.61.
7-1.6.1. Thank you, sir. Okay, now, with regard to the unstained area of the exterior of the jeans, do you see item 7-1.7.1?
Yes.
You found a DNA profile with regard to that unstained area as well, correct?
Correct.
How many contributors of DNA were there to that unstained area of the jeans?
I interpreted it as 4 contributors.
And John O'Keefe was one of those, correct?
He was included in the profile.
His own genes.
Based on the description, yes.
Who were the other 3 contributors to that DNA profile?
I don't know. It could be anybody.
And before we move on to the sneaker, I just wanted to ask you a question about the passenger side taillight that I neglected to ask you. That was the one where there were 3 contributors, correct? And again, I'm going back to 3-1.1.
Correct.
Sorry to skip around, sir. I'm not trying to make this any more confusing than it is. With regard to the passenger side taillight and that DNA profile, are you able to determine when that DNA was deposited on the passenger side taillight that was attached to the vehicle?
No, I'm not.
Are you able to testify with any certainty that it was deposited there, say, on January 28th or 29th of 2022?
No, I can't.
So consistent with your analysis of it, are you able to say whether it occurred prior to January 28th of 2022?
No, I can't.
Were you aware that that vehicle was John O'Keefe's girlfriend's vehicle?
I was not.
Were you provided any information about just how often he had been in and around that vehicle prior to January 28th of 2022? So moving on to 7-3.1, which was the right instep of the sneaker, correct? You see that in your report?
Yep.
With regard to that particular stain, you noted how many contributors of DNA?
Yeah, it was interpreted as at least 5 contributors.
And when you have interpreted as at least 5 contributors, what does that do to your ability to find out who contributed that DNA?
So based on our protocols, we're not able to do any comparisons to any mixtures that are 5 or more contributors. So it's not suitable for comparisons.
Okay, which means that with regard to the sneaker, at least, you couldn't even say whether John O'Keefe's DNA was on it, correct?
Correct.
And with regard to all 5, do you have any idea who contributed the DNA to that sneaker?
No, I don't.
Now, moving on to, I just have a couple more for you, sir. Moving on to what is labeled as stain L, which is 7-18.14.1, I believe. Do you see that in your report?
I do.
And that was a stain on the back bottom of his long sleeve shirt, correct?
Correct.
And were you told that the long sleeve shirt was his outer clothing when he was found?
I don't believe so.
How many contributors to that stain on the back bottom of his long sleeve shirt did you find in that DNA profile?
I interpret it as 2 contributors.
And did you make any match with regard to either of those contributors or both?
I did comparisons, and John O'Keefe was included as one of the contributors.
Okay, so John O'Keefe was a contributor of DNA to his own long sleeve shirt, correct?
Based on the descriptions, correct.
All right, and whose other DNA was on that shirt?
I don't know.
And then finally, with regard to 7-18.17.1, that was an unstained area of the exterior of that shirt, correct? That same long sleeve shirt.
Correct.
And you tested that and got a DNA profile, correct?
Correct.
How many contributors were there to that DNA profile?
I interpret it as 2 contributors.
Was John O'Keefe one of them?
He was included as one of the contributors.
Okay, so his DNA was found on his own shirt, correct?
Based on the description, correct.
And who contributed the other DNA profile to John O'Keefe's sweatshirt?
I don't know.
With regard to any of the stains on the upper right leg of the jeans, I counted 1, 2, 3, 4, 5 that you've discussed here today. Were you ever asked to compare the DNA profile with the DNA profiles of either Brian Higgins or Brian Albert?
I was not. Oh,
All right.
I'm sorry.
And your answer was you were not?
I was not.
Did anybody ever provide you with DNA profiles of Brian Higgins or Brian Albert?
Sustained to that.
So there he's asking specifically about Albert and Higgins. And look what Hank's doing. He's objecting because this is something that hurts him, because it shows covering up of the truth is vital to him to win in this case.
I'm sorry.
And your answer was you were not?
I was not.
Did anybody ever provide you with DNA profiles of Brian Higgins or Brian Albert?
Sustained to that.
Sustained. I couldn't hear the rest of why it was sustained, but this is again, you're not able to try your case. You're not able to bring out key critical facts to impeach this witness. It's a complete sham of a trial. This is not a real courtroom here. It just completely shuts him down. You weren't asked to test for 2 specific people. The culprits, right? The culprits she doesn't want being named as culprits and argued as culprits. Why is that? Why is the judge so much protecting the Alberts and the Higgins and the McCabe's?
One moment, Judge.
Yes.
That's pretty much it, surreal.
I just have one more question for you, Mr. Porto, and I do want to thank you for answering all my questions here today. You wrote reports on your analysis of all the items and the work that you did on this case?
I did.
And you are directed pursuant to protocol to address those reports to somebody, correct?
Correct.
Who was it that you sent the reports to in this case?
I'm sustaining the objection.
Did you send those reports to Michael Proctor?
Sustain. Jurors, strike the
Why?
question.
He's the lead prosecutor. Why can't you ask that simple question? But this is so unbelievable. I'm not even gonna get mad about this anymore. It's not worth it. This is almost like it's not like a real trial where you really have robust cross-examination, expose the government's incompetence.
I have nothing further. Thank you, sir.
Unbelievable.
Yes.
Absolute joke.
Mr. Porto, based on your training and experience in years of doing DNA testing at the lab, when it comes to
All right, Lally, we don't need to hear you. Let's go ahead and they next have this Ashley Valier. She's also a forensic scientist from the lab. And she did some assembling of the taillight pieces starting at 126. Again, we have Lally. So if they're really not an important witness for the prosecution's case, at least in their mind, then they leave it to Lally to do the direct.
yourself to the jury, spelling your last name for the court.
My name is Ash Valier, spelled Vallier.
And where do you work?
I work at the Massachusetts State Police Crime Laboratory.
And where did you go to school?
I got my bachelor degree in biochemistry and cell biology from UC San Diego and a master's degree in biomedical forensic sciences from Boston University.
Right. She assembled various taillight pieces. And then there was this motion regarding aperture with Alessi doing the argument for the defense. That's at 211. Let's go ahead and jump there. Okay, here we go.
All right, Mr. Alessi, I'll hear you.
You are unmuted.
Here's a follow-up to what we heard the other day, the day before. The prosecutor trying to change the timeline.
Thank you, Your Honor. Yesterday, Your Honor discussed with the parties, and parties were heard with regard to the issues we have raised with regard to the timing of the May 8th report from Mr. Burgess that the defense received on May 11th. And what I wanted to do, Your Honor, is briefly provide the information Your Honor asked for yesterday, which was how much time we might need under various circumstances.
Okay.
And so I wanted to take a few moments to put that in context. It will only take me a brief amount of time to do so. So, Your Honor, there is a timing issue, but there's most importantly a substantive issue. I will not, of course, go into the detail of yesterday, but the timing really is informed by the substantive issue. And so with regard to the matter, we went back and we looked at more deeply the effect of this timing and this movement of the what has been referred to as clock drift in Mr. Burgess's report that we got on May 11th. I spoke of the significance yesterday, and here's what I would like to add as is relevant to the time we're going to need. I again urge the court to reject it substantively, because what we did was we went and we looked at matters such as the cross-examination of a key witness in this case, Jennifer McCabe. She testified with
Yet they didn't bring up the fact that there was no requesting to test for dog DNA. I think that would be interesting if there could be some kind of way to test for the dog DNA, and they sent the clothes out, John O'Keefe's clothes out for dog DNA testing, but that didn't come out.
Regard to observing a vehicle at 12:45 a.m. We, and that's a significant point. I know I don't need to elucidate for Your Honor. All of this is going in significant part, if not total part, to what has been as alleged a collision here, which we vigorously contest. It just no collision ever occurred. But the timing of it, the timing of what's alleged by the Commonwealth is very important. The seconds are important. Literally 1 second can turn not only the Commonwealth's theory completely around in circles and debunk it, but also the jury's analysis of it. And this is the point I wanted to elucidate today, is that the jurors have been provided information and the defense has aimed.
Yeah, I don't think the location of blood dripping patterns is something that this guy is able to talk about patterns like a blood spatter expert type of thing. He's just testing what he's given. But yeah, that did not come out about him testing blood patterns. But obviously, I think the way the blood came down his shirt, if he got knocked out and he's backward, how did the blood drip down his shirt as much as it did if he's on his back? So nothing about this case from the prosecution makes any sense at all. The more you think you understand the prosecution's theory, there are more questions like, well, what about this? This completely puts that on its head. So here we hear about Alessi saying that the prosecution trying to change their timeline is putting the defense in a real big jam because they have done their whole case with the strategy that the prosecution has a timeline of when the vehicle strike happened, and now they want to change it with this new expert that has not testified yet. So the report of this expert is not complying with discoveries, and so that's what Alessi's complaining about here. It's like a trial by ambush.
Its defense on this claim based upon, in large part, timing. So now what we have is on May 11th, Mr. Burgess changing the timing. So what does it affect? Not only witnesses like Jennifer McCabe, who we strategized with regard to, but also my decision to not even cross Trooper Garino, because Trooper Garino had testimony with regard to when Ms. Reed connected with the Wi-Fi at One Meadows, and there's a certain time associated with that. We have Mr. Whiffen, who went through, the Commonwealth went through a timeline, and we believe they went through a timeline for the theory that they had. And I cross-examined Mr. Whiffen extensively with regard to that timeline. There were several defense strategies, and effectuations of strategies based upon that timing. So with regard to the substance, Your Honor, and there's more, but I think that's a fair representation. It innervates our entire defense. The question now of Your Honor of how much time it will take the defense to react to Mr. Burgess, I wanted to say it's not only a reaction, but it's a substantive defense analysis, and 3/4 of the effectuation of that has already occurred through our presentation in terms of cross-examination. So we would have to, and we're still evaluating that, revisit all of that. And secondly, we would have to put that into the calculation of all of our witnesses that we've already prepared that are based upon that timeline.
Sula, the reason they don't state the basis is that's the way the rules of evidence work in the state of Massachusetts. So the defense asked for that, for an exception to that. The judge denied it. And it really, I think, is a really poor way to have rules of evidence for trials, because what it allows someone to do is just continually object and not even know a sound basis to object, and the judge can just guess what the reason is. So it's a lot of guessing games, and allows somebody that just wants to hamstring the momentum of the other party, the other opposing counsel, to basically just constantly cut them off the knees. And the more the judge sustains it, the more you're encouraged to keep objecting. And it really hijacks the whole process. And you don't even have to be a good lawyer anymore. Just object constantly if there's something there that hurts your theory of the case and makes you look bad.
So it is a very significant point. And to the extent that the Commonwealth tries to argue, well, you know, we never really committed that much to a certain time period. I again urge the court to look at the report of Dr. Judson Welcher, where he has 1162-2 with a specific range 38 to 43. And even in their range, it's a very small time, which further supports how each second matters in this regard. Now to the answer to the question Your Honor asked yesterday. Again, I urge that it just be rejected and we keep this trial moving in its current pace. To the extent that that does not occur, and again, we urge that it be rejected, the report, because it's a Rule 14 violation, there is no remedy for the defense. However, to the extent, and given Your Honor nonetheless asked me for an answer in time, we would need 4 days to be able to address it. We will not ever be able to recover strategically or substantively from it, given all that's been presented to the jury. And it will be very difficult to figure out how we're going to go present a defense after we've already presented to the jury our defense and our cross-examination. It's not really structurally possible to simply take 4 days and address Mr. Burgess, because we can't go back to all the witnesses I just mentioned and others and start crossing them and eliciting testimony with this new time period in mind. But I wanted to answer the question, Your Honor, respectfully. It would be 4 days for us to even go from where we are now and then try to alter not only witnesses such as Arca, but Sogra and Gaffney and other types of witnesses that we have in that regard. So Your Honor, respectfully, that is my response.
All right, does the Commonwealth want to be heard?
Yeah.
Okay.
I'm not sure the defense is as concerned about this as what they're making it out to be, because I think that them moving their timeline again is going to help the defense show that they don't even know their theory of the case. They're still trying to investigate it. They're still coming up with different angles of argument, different data, and the data keeps moving. And so, and the other thing is the way they're trying to make it look that this incident with the car strike happened later. I think the later they make it happen, the more that issue with Karen connecting to the John's Wi-Fi at 12:36, it makes her further and further away from being there at 34 Fairview. So,
Respectfully, Your Honor, the defense is very confused. They attempt to confuse the issue. They attempt to confuse Your Honor about what the impact would be. This has never been a change.
well, that's not true at all. Of course, they've been questioning witnesses based on the timeline you've been arguing in your opening. You said it was 2:31 in your opening, 12:31. I mean, so
The government is not changing
that's the kind of spin this guy puts on everything. You can't believe a word he says.
their timeline. The Commonwealth is not changing any information. The Commonwealth is not offering anything that affects in any way the testimony of witnesses. It's notable in the argument there is no relationship to the facts or the actual report that was provided. The Commonwealth has always.
Yes, the defense could ask for testing, but they don't have samples of Higgins and Albert. How are they going to get those samples?
Always provided the data, which they have, and they hadn't a chance to analyze. And the interpretation of the data has been different between the parties. We have been clear from the beginning at the time in which the infotainment system shows that there was a collision. We've been clear. And the data has been clear. That has never changed. That data in the telestream system is based on a clock in the Lexus, which both sides know full well is different than a clock in an iPhone. You can see all the productions of Dr. Welcher's PowerPoint presentation where it shows that time, 12/31/43, has never changed. Also, it has been clear that both sides appreciate that there is a variance between the clock in the Lexus, which leads to that system information, and a clock in an iPhone. In fact, the defense was so aware of it, they hired an expert, Mr. DeSorga, who gave his opinions about that variance. We have never suggested there was not a variance in this case. In fact, we have highlighted the variance. When their expert, Mr. DeSorga, provided a report, we believe that his analysis was wrong. And so we looked at the variance and the data that was available from the Telestream system and John O'Keefe's Waze data that was on his phone that was always available to all of the experts in both sides. And when Mr. Burgess looked at the variance at the time of a three-point turn about 7 minutes before the collision, he simply matched the Waze information on Mr. O'Keefe's phone to that of the information from the Telestream and saw that it was a 21 to 29 second variance. All that data was available to the defense because their expert made an improper conclusion is not our fault. This does not change the testimony of anybody.
Yeah,
They
right.
point to Jen McCabe's text message where she said she thought she saw a motor vehicle out front that evening at 12:45.
Back to Jen McCabe, yeah, at 12:40. She thought, no, she was very clear about it in the first trial. And then the second trial, she said, oh, I don't know. And she's completely backtracking. Why would she backtrack? Because she knew her timeline was completely destroyed by other digital evidence.
That is not consistent with the Commonwealth's timeline, but that doesn't change. That favors the defense. It does not change anything to do with ARCA. ARCA has not, as far as I've seen in any reports, ever talked about the variance, just Mr. DeSorga. And so because this is inconvenient for the defense, and because it further focuses the variance that we already discussed and provided, isn't a reason to exclude it. It's not late discovery. It's not a Rule 14 violation. It is further analysis of information that was already provided, opinions that were already provided, and it is in response to their experts' mistake about that variance. There's nothing new here. Nothing has changed.
Yeah, right.
Go right ahead.
Then why did he supplement his report if nothing's changed? So it's all smoke and mirrors.
Mr. Leslie, the only question I had for you yesterday, for you to respond to today, was the time, so I gave you more leeway.
And
So
you're giving me more leeway, and I appreciate it.
go right ahead.
So 2 items, Your Honor. As I alluded to yesterday, and it's been a point that Mr. Brennan just made. We believe strongly, Your Honor, that at a minimum, there needs to be a voir dire of Mr. Burgess. And we believe strongly there needs to be a voir dire because we have a serious concern that the sequestration order has been violated. He has changed a very key aspect of this matter after the testimony of Mr. Whiffen, after Mr. Whiffen presenting a timeline. In his report, Mr. Burgess, his new purported report of May 8th, he references to align it with Mr. O'Keefe's cell phone. That is the essence of Mr. Whiffen's report. It is anchoring in his timeline. He did a whole timeline on Mr. O'Keefe's report. And conveniently, the proposed alteration by Mr. Burgess in his report of this clock drift now makes it very, very close to fitting within Mr. Whiffen's timeline and the theory of the prosecution. At a minimum, we need a voir dire to ask Mr. Burgess, why did he do what he did? Another reason for the voir dire. Mr. Brennan yesterday said, we were...
Yeah, but voir dire is only for the judge and the prosecutor to be able to beat up your witness's defense. That's not something that you have equal rights to. You don't have due process in this courtroom.
Surprised to get the report. That further makes great concern as to why Mr. Burgess did what he did. Lastly, Your Honor, with regard to Mr. Brennan's point, he made it yesterday and I corrected it. He said it again today, that supposedly our witness, Mr. DeSogra, made an error and that we're trying to correct an error of Mr. DeSogra. That is incorrect, Your Honor. Again, Mr. DeSogra was responding to Mr. Burgess's report. Mr. DeSogra's report is entirely saying, okay, Mr. Burgess says this, and therefore the defense says this. Now Mr. Burgess is changing what he is saying. So it is completely incorrect to say that Mr. DeSogra is trying to correct an error. That would require, again, Mr. DeSogra to change what he has done. Final point is this. There was also an issue, Your Honor, and this is extremely important with regard to burden shifting. There's not only the question of should this be allowed.
That is true. Then that would be another way they could get it. But if the state doesn't request it, the defense cannot ask for them to test it. It is a state facility and lab, so the defense can't force it. It had to be approved by the judge. But the burden's on the prosecution, not the defense. So the defense doesn't ask for that. That's not to be held against them.
At all. There's not only the question of how much time the defense will need, but there's a third and important issue, and that's burden shifting. What Mr. Brennan proposed yesterday was a very irregular process where essentially the Commonwealth gets 3 bites at the apple for a problem that they caused. The problem we're talking about is Mr. Burgess changing a significant part of a timeline. Yes, there was a variance that he had, but he picked a range of the variance. He's now changing the variance. So what the Commonwealth is proposing is that our witnesses go forward, the aperture gets to wait, they come on, and then the aperture gets to come on yet again. We would.
I did not understand the Commonwealth asking me that. Are you asking me to do that, Mr.
I
Brennan?
appreciate the
I'm
clarification.
not sure what he's saying, so.
It sounds like DeBroja or whatever,
His name is DeSoga, yes.
DeSoder, you're suggesting that the
No, I don't find him to have any kind of voice that a jury could tolerate and listen to day after day after day. All these objections, delaying it out. These people have their lives they want to get back to. And this all looks like a big game to the prosecution. And he's not credible or trustworthy from the way he's acting.
Commonwealth suggested yesterday that he testifies first and then the aperture witnesses?
What I understood was going to happen is Mr. Brennan said yesterday that Dr. Welcher cannot come in until after.
No, I didn't understand that. I understood Dr. Welcher, Shannon Burgess, and then Dr. Welcher for everything that you folks received prior, January 31st or whatever the date was. And then potentially for all the new ARCA information that came in May 7th, that portion, Dr. Welcher returning on rebuttal for. Not that they were holding back Dr. Welcher completely. Is that correct, Mr. Brennan?
That's the conversation I had. That conversation I wasn't part of.
Yeah, I think you misunderstood that, Mr. Alessi.
So just so I'm clear, what is it that the rebuttal?
Mr. Brennan, all right, this is separate and I'd really like to give everybody a break here. What is it the Commonwealth is asking to do regarding that?
Regarding Mr. Burgess or Mr. Welcher?
Which, Dr. Welcher?
Dr. Welcher should come in and testify to his PowerPoint, all of his opinions, which address all of the prior representations and opinions of ARCA, although we still don't have any raw information, but we're ready to move forward. Regarding any new opinions, which there is over a dozen new opinions that includes testing, video, experiments, Dr. Welcher should have enough time to review, conduct his own testing, turn it over, and then in rebuttal, address limited to the new issues raised by ARCA.
That's how I understood it, Mr. Alessi.
And that's how I did also, but the question is now with the Burgess changing of the clock drift, how many times is the Commonwealth proposing that Dr. Welcher gets to come in and talk about that? Is he just going to come in and talk about it?
So you talk with Mr. Brennan about that. All right, so I'm all set for this.
There are no changes. There is no changes in the timeline. He keeps trying to portray this as something has changed. Nothing has changed. It's the exact same. He's always said there's a variance. He's been looking into the variance for a long time, and now he has found a method to show the exact variance. It's not changing. There's nothing in the reports that changes as far as the timeline. That's just an attempt to cause fear. There's nothing that has changed. We can look at the reports. It's all the same, always has been, other than now he's identified the mistake of their expert, and that led him to be able to identify the variance, which is helpful and new. And the suggestion that there's been some violation of an order, no good faith basis whatsoever. None.
Does the Commonwealth oppose a voir dire just on that one issue?
Yes, because it's suggesting that there's a good faith basis for it. Nothing has. Ian Whiffin's report was available to the defense and our experts months and months and months ago. The issue of variance has been an ongoing issue for months. There's nothing that triggers a change in the testimony to adopt or adapt to it.
But if you say what the variance is at one point, then you change it, you're changing your timeline.
Timeline has been the same since when we turned it over at the beginning. They cannot point to one thing that has changed between Dr. Welcher, Ian Whiffin, Jessica Hyde, or Shannon Burgess. They are just saying things without a good faith basis. In the reports, show us where something has changed.
Your Honor, to inform you, Your Honor, we would like to print the page in the clock adjustment because what Mr. Brennan says is
Yes,
correct.
and I'm happy to any information.
Thank
All right,
Change.
20 minutes.
No.
Thank you.
All rise for the court, please.
Unreal. Just all the spin going on here by Brennan. He knows that this is a big deal. They're changing a window. And so let me show you something here. Trying to show here this, trying to zoom in on this here. All right, so this is the timeline here, according to Ian Whiffin, the prosecution's witness, that talked about all this kind of digital data with the phones and the car and the Wave app and all that. So everything in a box here is what he testified to. So you can see here at 12:24:38 a.m., John O'Keefe Rise 34 Fairview. Then on the bottom, you can see some of the unlocks of his phone in the brown boxes there. Some of this Doppler pocket state that also that Ian Whiffin talked about is there. Up here in the blue boxes, this has to do with Jen McCabe's messages to him, including this 12:31:47 seconds iMessage from Jen McCabe saying, "Pull behind me." And then, so what's changing here is the stuff that's not in the box. So this has to do with the infotainment trigger of the Lexus. Apparently 12:31:38 a.m. was a start trigger date, a timestamp, and then the ending of the triggering event was 12:31:48 a.m. And so you have just those few 10 seconds. So what this Burgess is trying to do now is trying to change the start date time stamp to 12:32:16 a.m. Because if it starts there, look what, if you go up to the green box up here, look how coincidental that is. It ends at 36 steps of John O'Keefe's his Apple Health Watch, his Apple Health device. The end of the 36 steps happened at a precise time. So it looks like he got information more about the case, and he's trying to sync his testimony up with Ian Whiffin. So that's what they're trying to do here. And so this is this is never aligned here. So if you look at this, none of this data stuff here on the timelines for these different electronic devices matched. And now they're trying to say, oh, look at this here. Now they do match. So I think obviously the defense can bring up the fact that looks like he's trying to change his testimony, change his expert opinion. If he's an expert, why would he change his opinion? And he obviously was talking to somebody or viewing something. The witnesses, including the experts, are supposed to be sequestered. He should not be looking at what Ian's report is. But apparently he did look at Ian's testimony report. And then he's now coming up with a way to align that certain timestamp. So I think, like I said earlier, the further later that they're saying this incident happened, the better off in one sense it is for Karen, because Karen was already back at John's house. We know from Wi-Fi at 1236. And any of these, I think when you connect to Wi-Fi is much more reliable than a lot of this wave and phone and car stuff, because there's a lot of stuff that can go wrong on these kind of data things. Keep in mind, Whiffen was also testifying how he drove along, and the steps he discounted as being merely the hills surrounding 34 Fairview area. And then we saw Court TV's Vinny Politan said he was driving around. It looks completely flat, and his Apple Health data didn't show any changement of steps whatsoever. So that right there shows you this guy is Ian Whiffen. He really came across as a salesman. Also, he tried to make a pitch about his products he has for sales. So it's not a credible testimony, I think, from Ian Whiffen on a number of levels. And I think that in the end, when you're constantly fudging numbers and you know that Apple Health stuff is not always going to be synced up with other phones and this and that, I think if it's exculpatory, if it helps Karen, I think it's probably more credible. If you're going to convict somebody based on different devices like that, that's not really something you want to put a lot of stock into. I mentioned this before. I didn't mention what device though, but for example, my wife used to have an Aura ring, and that's sort of like an Apple Health thing, and you could normally find out what your steps were, how much it's sort of like Apple Health tracks your heart rate and stuff. And what happened was she would go for like a multiple mile run and would never record her running at all, kept her heart rate the same. Instead of multiple miles, it would only show like a tenth of what she actually ran. So no elevated heart rate, no great distance traveled in terms of multiple miles, and all these other indicators showed how wrong a device like that can be. Yet they're trying to make this all out to be absolute concrete, ironclad truth. And keep in mind, a lot of stuff Whiffen always said, he hedged it with, I believe. He mentioned many times, I believe. So that's sort of his out. He believes. He's trying to sell a product. The more he can support the prosecution's theory, the more he's going to be used by more prosecutors around the country. So I just don't trust that to the extent the prosecution's making it out. And I don't think the jury, who is made up of younger folks, and they're more tech savvy than me, obviously, but I think that the Wi-Fi is going to be is the alibi that Karen Reed has for this case. Yeah, no, it wasn't my wife's, Leslie. It wasn't her Apple data. It was the Aura ring. It's like an Apple Health device. I think those are watches, right? So anyway, a lot of that stuff it's tracking can be totally wrong. And that's why people buy it. It's to track stuff, your heart rate, how many steps you take a day. And also, Leslie said that if the battery's lower, like if it's 20% battery life versus 100%, it's going to be less accurate. And that also is a thing to keep in mind here, that when we heard about the accuracy of things or lack of accuracy, we also have, let me switch this out. And I'm going to add something here. Look here, this is some of the cross-examination of Ian Whiffen. And I'm going to make this full screen. So it's like you can even be falsely recorded as moving when you're not, and vice versa. And so it all has to do, in large part, with the accuracy, and it has to do with the connection. If your device, your phone, is not connected well, then you can have, for example, here in the third paragraph, it says, for the reason for such low accuracy location data at this time is not known, as there are many possible reasons why the accuracy was to be reduced. It could include reasons such as device entering a building covered area, the result of weather conditions, geography, poor connectivity, or interference, to name a few. So yeah, if you're walking around with a device or driving around, all those kind of connections are interfered with on a continual basis. So it can have you not moving when you're actually moving because the connection's bad. And then when the connection's good again, then suddenly you pop up as being like, oh, well, you suddenly moved a mile. Anyway, it's just, it can be helpful, but it also can be very misleading. And to make it look like it's the end all and the absolute arbiter of truth is going to get you in a whole lot of hot water and get people wrongfully convicted. So that's all I'm going to say on that. Yeah, like walking undercover, like walking into a house. All right, so let's go back to Friday's hearing. They didn't go past lunch hour. Let's watch some of this. Ashley Valier.
Or mechanical fit analysis that you did with regard to each of the items individually, correct?
Yes.
And can you explain for the jury the process that you undertook in your physical match analysis between different item numbers?
So between different items, amongst the questioned ones, I only compared the pieces that were large enough to have a label on them. Some pieces were quite small. I utilized several benches and divided them up into sections for each item, and individually pulled out all of those pieces. And then I had another bench where I did the actual comparison. I started with all the pieces of the same color and looked to see if any of those had potential edges that could match.
Now, with respect to items 715 and 716, did you do a physical match analysis between those two separate items?
May I look at my notes?
Yes.
Okay. Yes.
And what, if any, conclusions did you come to in relation to your physical match analysis between item 715 and item 716?
Two pieces from item 7-15, F and H, fit mechanically with two pieces from item 7-16, F and G.
And what, if any, conclusion were you able to draw with reference to the physical match between pieces from item 715 and pieces from item 716?
Those four pieces were at one time together as part of a larger unit.
Now, Mr. Lear, what physical match analysis did you do with reference to item 7-6 and 7-11?
So one piece from item 7-6, piece B, fit mechanically with one piece from item 7-11, piece D. So those two pieces were at one time together as a larger unit.
And Mr. Lear, with reference to items 7.8, 7.9, and 7.16, what, if any, conclusions were you able to draw from any physical match analysis you did between pieces from those three items?
So 2 pieces from item 7-8, pieces C and D, 1 piece from item 7-9 piece A, and 1 piece from 7-16 piece E were found to have a mechanical fit. So those pieces were at one time together as a larger unit.
Lastly, for this section, at some point, did you do a physical match analysis for the glass pieces in item 7-12 and 7-14?
Yes.
And what conclusions were you able to draw from your physical match analysis between 7-12 and 7-14?
There was no physical match between the glass pieces from, or parent glass pieces from 7-12 and the glass piece from item 7-14.
Now, Ms. Clear, are you aware that there was an additional analysis that was done with respect to glass pieces and other glass pieces that you didn't examine in your analysis at your lab?
I know that there was other trace work done. I'm not sure exactly what the work was.
Okay. And do you know who performed that additional trace work?
Christina Hanley.
And who is she to you as far as in reference to your work at the lab?
She's my supervisor.
Now, with regard to each of these items individually, they came as labeled in individual bags as we demonstrated on the screen, correct?
Yes.
Okay. And with respect to those bags, did you note any particular date associated on the front of those bags?
That's documented in my photos.
And all I'm asking here is that with respect to each of those bags of items, whether they be 3-1, 7-4, 7-5 or 6 or 8, many of those bags had different dates on them, correct?
Yes.
Okay. And when you received those items in that bag, you essentially removed the items from those individual bags, placed them on the table, and examined them, correct?
Yes.
And that examination included a microscopic examination?
Yes.
Now, with respect to any of those items, there were some items that pieces within the same bag that had the same date on that bag did not fit together mechanically, correct?
Yes.
However, there were items from one bag collected on one day that did fit mechanically with items from another bag collected on another day. Is that correct?
Yes.
Now, if I could turn your attention to item 3-1. Again, for the jury, what is the physical description associated with item 3-1?
Item passenger side taillight, Massachusetts 3GC684.
Now, did you perform a physical match analysis with pieces from item 3-1, 7-5, 7-6, 7-8, 7-10, 7-11, 7-12, 7-13, 7-14, 7-15, and 7-16?
I compared them, yes.
And what, if any,
All right.
conclusions did you come to from your analysis, your physical match analysis between item 3-1 and all of the items beginning with the number 7?
There was a physical match with, do you want me to list?
If you
all
could,
of them?
please.
Okay. So 2 pieces from item 7-
All right. So any of the matching the taillight, how is that even credible? They're going out there multiple days. They're trying to say all these pieces just happen to fit together. You know, one person found it this day, another person came out the next day or 2 or 3, and they just sort of happened to magically come up with most of a taillight. However, you compare that to what we saw there at when Karen left John's place at One Meadows, you can see she mostly had her whole taillight intact. So, and when the trooper showed up the next morning and they looked at the back of her car there and had those cameras we saw, the photos that they had from the car cam, the video cam, it looked like there was still a full plastic taillight in place, and there was no depression from the polycarb being gone. So a lot of this is so much smoke and mirrors.
Coming, yes. If you could even zoom in just a little bit more on the item itself.
They had plenty of chances to try to make this light the central point of the case. And you're telling me these big pieces of plastic, they had to wait many days for the snow to melt? It's just not even credible. So with that,
Ms. Gilman, if
I'll go ahead and go to a Q&A now. If you guys have any questions, go ahead, please put them in a red emoji if you know how to do that. And there's some pieces that didn't match. So why would they have unmatched pieces? Yeah, pieces that did not fit. John was not hit by a car. Well, where are these extra pieces that are missed? Where would they have gone? So it just all makes it look hokey. Crime sleuth, no salt and water mark spots on any piece they found. Either they're all clean before they planted. Her SUV was covered in salt and water spots, but light pieces all clean. That is an excellent point as well. And I did forget. Thanks for alerting me. Hold on a second. Sorry about that. Leslie just let me know I forgot to cover the end of the case where there's a ruling from the judge. And of course, we know what the ruling is going to be, right?
And may I publish, Your Honor?
Yes.
Ms. Gilman, if I could have,
Let's go ahead up to the judge's. Let's see. You know what? We'll do the cross here. It's only 13 minutes.
The taillight to which you've testified. At the outset, by the way, that was item 7-3.1. Am I correct?
Sorry, for which one?
That's the taillight, this 7-3.1. Am I correct?
3-1, I believe.
7-3-1?
The taillight is item 3-1.
Oh, 3-1. I'm so sorry. Okay. With regard to that particular item, your lab has different departments, correct? Criminalists who do different things, correct?
Yes.
You are aware that there are scientists within your lab who do DNA analysis, for instance, correct?
Yeah. Yes.
And with regard to the order of processing items, is the DNA analysis done before or after you get the item?
It's usually before.
Okay. In this case, it was before. Am I correct?
I believe so.
Were you made aware that there were 3 contributors of DNA to that taillight, 3-1?
I'll allow it. When you made aware of that.
No.
Maybe judges allowing a few more things to come in from the defense based on the juror comment that we heard about.
Once you reconstructed the taillight, you'll agree with me that it was missing a piece, correct? Or pieces?
There was an empty spot on the overall reconstruction, yes.
Were you ever provided with any pieces of taillight that would have filled in that missing spot?
No.
Were you ever provided or told about any pieces recovered from One Meadows Ave in Canton?
No.
Were you ever told about a collision at One Meadows Ave in Canton?
Sustained.
In any case, you'll agree with me.
Why would that be sustained? That could be relevant.
There was no glass in that taillight at all, correct?
Within the taillight, I classified them as apparent plastic pieces.
There's no glass as part of the taillight, correct?
I mean, it depends on what you call, like, the bulbs usually have glass as far as I'm aware.
Those are very, very thin glass, though, correct? Those bulbs?
Yes.
All right. Now, your lab received clothing in connection with this case. You've testified to that, correct?
I received the debris labeled as coming from the clothing. I never saw the clothing at all.
Right, but you're aware that your lab received clothing before the debris got to you, correct?
Yes.
And your understanding was that that was John O'Keefe's clothing in which he was found on January 29th of 2022, correct?
It's labeled as coming from him. I'm not sure of the date that it was found.
Okay. You understand the procedure of that goes on at your lab when it receives evidence?
Yes.
And you know that once clothing is brought to your lab, it's given evidence numbers, correct?
Yes.
And then one of your colleagues at the lab handled the clothing and or examined it, correct, before it came to you?
Yes.
And your understanding is that one of your colleagues retrieved debris from those items of clothing and then packaged it in a fold before it got to you, correct?
Yes.
You then open up the fold and you look at the debris, correct?
Yes.
You never saw that debris inside the clothing, correct?
Correct.
And
I had not heard that before, Lubin Dubin. So we don't know what the truth is. The original story was put out there by Howie Carr. He had heard it from somebody else. So we don't know the accuracy of that. But I think something happened because otherwise the judge would not have made this comment to the jurors about them talking and bothering other jurors. So, and it was made that they were talking while they're in the courtroom. It didn't sound like they were talking about them talking outside the courtroom itself or in the hallway or back in the jury deliberation room.
pieces of clothing that come in are given evidence numbers when your lab receives them, correct?
Yes.
For instance, the orange t-shirt was given or was named item number 7-17,
Yes.
and the gray long sleeve shirt was item 7-18, correct?
Yes.
And your lab is accredited, correct?
Yes.
There is a complete chain of custody from the moment the clothing was brought to the lab to when the debris was removed from the clothing, ultimately to when you're in court today handling the items, correct?
Yes. Our in-lab chain of custody extends from when we receive it to when the submitting agent it is returned to the submitting agency.
Okay. And you
Leslie Hicks, you're asking what I think about how the defense will do a workaround for this ruling. You're worried that Hank will just object and judge will sustain and they won't get the point across. Hopefully they'll be able to bring it out. I don't think they need to bring every single witness out they had cross-examined beforehand, bring them back to the stand, but we definitely have a lot of ability to impeach the aperture witnesses, and also you could use ARCA for that purpose, hopefully, to rebut them and explain why they had not made the mistake, but it's Burgess. Or else use Green for that purposes, their witness Green.
have complete confidence that the chain of custody at your lab is effective at making sure that the evidence does not get lost or mixed up or contaminated, right?
I mean, the chain of custody is meant to track where a piece of evidence is. The evidence unit also does inventories and audits to make sure that things are where they're supposed to be.
And you have confidence in your lab's chain of custody policies and procedures, correct?
Yes.
But you'll agree that your lab cannot control who handled the clothing before it arrived at your lab, correct?
Yes.
There are times in which crime scene technicians or criminalists from your lab actually participate in the search for evidence at a crime scene, do they not?
Some of the people at the lab are crime scene responders, yes.
There are times when they actually take custody.
John Kirk, I think that lucky the snowplow driver is very credible. I think he had courage to come forward and admit to what he saw that night because he actually knows the Alberts. He probably knows the fact that he could have some ramifications in his personal life for making the testimony he did. So, yeah, the fact that he never saw a body out there and all of a sudden the Ford Edge wasn't there when he first went by at 2-something in the morning, when he comes by around 3:15, 3:30, then all of a sudden there's a Ford Edge right blocking the view of where John O'Keefe's body would be. So who drove that Ford Edge? I mean, that's a big thing of this case. I think hasn't been covered enough. that Ford Edge driver, there wasn't enough snow on the ground. John O'Keefe would have been easily seen. So it looks like there's a cover and concealment effort going on with who has that Ford Edge. So there's at least 2 or 3 Ford Edges in the Albert family, including Brian Albert, whose house was there where John O'Keefe died. It was his front yard. So was it his Ford Edge, or was it his one of his brothers? So that hasn't been run to ground good enough, I don't think.
Custody of evidence, again, I'm talking about people from your lab, professionals. They take custody right from the crime scene and transport that evidence to your lab, correct?
Yes.
In those circumstances, your lab would have a complete chain of custody from discovery to seizure to testing or whatever comparison you're doing until you release the items, correct?
Yes, but the electronic chain of custody doesn't start until that item is entered into our LIMS system at the lab.
Right, but when it's entered in, it would be entered in as having been seized by somebody from your lab, correct? In the hypothetical that I'm giving you.
Yeah, there's an evidence submission form that says that this crime scene responder submitted it to the laboratory.
There are other cases, however, when the evidence is brought to your lab by the police, correct?
Yes.
Local departments have access to your lab?
For evidence drop-off, yes.
The state police have access to your lab for evidence drop-off?
Yes.
And in this case, it was not a criminalist or other professional from your lab who seized the clothing and brought it to your lab, correct?
I'm not sure.
Do you have a record of that in your report in terms of who it was that brought the material to your lab?
I could look at the evidence submission form to see who.
With the court's permission?
Yes. Okay.
All right, let's see. I'm going to jump ahead. So jury's dismissed a few minutes later, and then let's see at 3:34 we got a ruling from the court.
Were you aware of the date of the incident that gave rise to this case?
A couple more minutes.
Yes.
And what was that date?
January 29th, 2022.
Were you aware that the clothing that you received was seized from the Good Samaritan Hospital that very day?
No.
What date was the clothing brought to your lab?
March 14th, 2022.
So that means that your chain of custody at the lab began on March 14th of 2022, correct?
Yes.
And would you agree with me that was about 6 weeks after the date of the incident, January 29th of 2022?
Yes.
And of course, you can't speak to the chain of custody from January 29th to March 14th of 2022, correct?
Correct.
And you have no information and do not know why Michael Proctor waited 6 weeks to bring this clothing to your lab, do you?
Sustained.
Do you know where Michael Proctor stored this clothing
Legitimate question.
during that 6 week
Not
period?
here, though.
No.
Do you know how often he was alone with access to the clothing during that 6 week period?
Sustained.
Do you know if he had access to pieces of red or clear taillight during that 6 week period?
Sustained. Move on, Mr. Yanni.
Yeah, don't bring up anything about Proctor in the evidence, right? What a cover up. So I'm going to talk about that more later this week, about how this trial is actually helping the defense, despite all this anger and frustration we see about what's going on. It's actually helping the defense, and I'll make that point later this week because we have a short week coming up here. We have a half day Thursday, and then they're off Friday, and they're also off Monday for Memorial Day weekend. So there's a huge break. You're telling me jurors aren't going to be checking out the internet, see what's going on?
You were not present when the clothing was seized, correct?
Correct.
You did not have custody of this clothing from January 29th of 2022 to March 14th of 2022, correct?
Correct.
You do not know what was done with the clothing before it arrived at your lab, correct?
You've covered this, Mr. Mayor. Move on, please.
One last question. You cannot vouch for how the clothing or taillight pieces were handled before they got to your lab, correct?
I cannot.
Anything further, Mr. Lally, or are you all set?
Yeah, just come on, move along, defense. We're sick of you guys. You have no case. You're wasting our time.
Mr. Lear, there is a separate evidence unit contained within the Massachusetts State Police Crime Laboratory, correct?
Correct.
Enough of
And
that. This is pretty much a throwaway. So now we'll go up to 334. Here we have the judge fixing things for the prosecution again.
May be seated.
Okay. So before we recess, I appreciate the council provided me with the information. Mr. Leslie, I got the 2 reports that you had that were incorporated in what the Commonwealth had given me a few minutes before, but I appreciate that it was pointed out here. We've had full argument on this yesterday and today. My findings for the record are that the defendant has not persuaded me of undue surprise or unfair prejudice by this information, and I don't find that there's delayed disclosure. Of course, all of this is ample game for cross-examination.
Yeah, which will be objected to, and you'll continually sustain the objection. So is this all a sham court? And here's what she never does. She always makes declarative rulings. She never makes any findings that the timeline changed from this to that through different witnesses. There's no findings. She just declares it. And I wish defense would have put it in writing, and that would have had a little bit more compulsion for her to have to make a written ruling. But even then, many times she doesn't even come up with the findings. So it's really a one-sided railroad court here.
Certainly as to what Mr. Burgess knew, what he looked at, why he looked at it, when he looked at it, why he changed his report, and violation of the sequestration order is all for cross-examination, and I will give you a lot of leeway with that, Mr. Alessi, but I'm not having a voice.
Well, you should anyway, because there's constitutional rights that are implicated here. Lots of special, you're getting really special treatment when the prosecution continually changed their timeline of how and when John O'Keefe was struck.
Idea on that. Mr. Alessi, I can tell you, obviously, you've got a great facility for cross-examining on the underlying information here. You've done fulsome cross-examination.
It's all a false hope.
I have every confidence you can do it here again. But if after the direct, you demonstrate that you need further time, I'll certainly hear you on that. And more importantly, perhaps, if you feel that the testimony of Jen McCabe and the others that you've mentioned is critical and that you need to recall them, I'll hear you on that as well. So regarding Dr. Welcher, as my understanding, the request yesterday was for, and it's been a request, I think, a few days. We've addressed it at sidebar, and I found that it wasn't the right time. Let's see how much Dr. Welcher could go through. I understand Dr. Welcher will testify in the Commonwealth's case in chief next week or so, Mr. Brennan.
Hopefully next week, if not
All right.
the day after the holiday.
And that will be for all of the material that was provided to the defendant initially, right, by the Commonwealth's discovery deadline?
Correct.
And what you're asking for is that after ARCA testifies the new information, you're asking for rebuttal, right?
Yes, limited to the new information.
All right, so I would allow under these circumstances a limited rebuttal, and we can define the scope after we hear the testimony of ARCA. So those are my rulings. Your objections were noted. I'll see everybody on Monday.
All rise for the court, please.
Monday, I thought they're not having court on Monday. Let's see. Maybe that's the following weekend, Memorial Day weekend. So I must be wrong on that. Mr. Monks, understudy, do I know about the rug Karen has stored from 34 Fairview, as mentioned in the Vanity Fair article? I've heard about this, but I don't know if that's confirmed or not. And if there is that rug, and then it could be tested, they could have independent testing for DNA, but we don't know if that's even any of that's true. That's Ashley's opinion. So to make sure Lucky didn't come whenever go time was, they parked the edge. Full melt hash is my opinion on the clown on Twitter claiming you were encouraging jurors to watch and research trial. Okay, well, I was never encouraging jurors to watch and research a trial. I'm saying, from what I know from past experience, jurors do research on their own and look stuff up and Google stuff. That's the only thing I've been saying. So, and what I've said tonight was, I think that the frustration that the jurors are feeling, not all, but I might suspect that the frustration that a number of them feel would make them want to go ahead and do that. I just don't believe it that nobody's heard anything about this case outside of that courtroom and the 3.5 weeks that this trial been going on. Well, actually, it's now 4 weeks. 4 weeks of trial, and they've not heard a single thing about this case from anybody, not even accidentally. So anyway, it's just human nature, and so I'm not going to comment any more on that. But I don't know what you're talking about some clown. All right, let me get out of presentation mode. Thank you. Nee Brown, do I think the butt dials are maybe codes for actions taken? Anything's possible. Anything's possible if people are panicked. The butt dials are really hard to explain. We haven't heard all those yet come out through this case. Sam, you're saying you'd be Googling for your church because Hanks has made it so confusing. Well, he's objecting to so much. If you're doing that much objecting, the judge is sustaining all that, and it's sort of a one-sided justice system, you're actually encouraging jurors to do this kind of thing. So I'm just talking about human nature from what I've seen from other cases. Yep. And if they're not researching it, then we can talk about it, right? So how can I encourage jurors when I don't know anything about who they are? So it's just, there's some trolls out there that don't like me covering this case. So no, it's I'm Central Time, so it's just 11:02. Denise Sanders, so far in the prosecution's case, they haven't proven that John was hit by a car. No, they haven't. I don't think they have at all. Joy Moore, that's what I would do if this was my case and I was a defense, being that frustrated with the judge blocking you every time you get a critical question you need to have answered, you get blocked. Amy Carter, that's a lot of folks' theory. The butt dials were mostly calls to find John's phone. Verdict statutes, you're asking Could they ask to test Higgins' snowplow? Reason being, if you look at when the Higgins changed and went to the station to supposedly move cars, if you look at the passenger side, the snowplow's suspect. Yeah, I mean, there's theories that he could have hit the snowplow, he slipped and fallen, hit his head on the back of snowplow. I mean, that could leave that kind of injury as well. So any number of theories is possible. It's not the defense's job to present every possible theory, but the prosecution cannot come up with a cogent, logical explanation of what happened to John O'Keefe. Yeah, so that's what I was saying. They're not watching it, so why would they be influenced by any of us commenters? A little misread. Velvet, you're saying, do I think it'll be a problem if for the Commonwealth if Proctor, the lead investigator, is not called? I think that either way, it's a lose-lose scenario. So my suspicion is that they will not call him, and they're just gonna try to have the defense call him and then try to block to all the questions they want to have brought out. I mean, I've talked to a juror before that said they did this, so it's not just me being suspicious of it. I've talked to a juror that said this is what was going on a different case. Jennifer Rank, the state is corrupt and clearly conducting a sham trial. Why shouldn't the jury conduct research? Well, because they're not supposed to. I mean, that's the jurors are supposed to follow the instructions, and so that's what they should do. But it's sort of like when they see such outrageous stuff going on, I think their curiosity is going to get the best of them, so they're going to be very tempted to do that. And you're saying a woman's liberty is at stake and the state's trying to hide the real evidence. Is this ethical? Well, ethical is really a term of significance for lawyers. So I wouldn't say this is an ethical issue. It's a constitutional issue about the defense being denied an opportunity to present their case. So this case is never going to survive on appeal, as I've said many, many times. Yeah, Queen of Hearts, you're saying Jen's 911 call said they flipped him over. Carrie said his face was covered with snow, and Karen lifted up his shirt before either of the others got there. Jen was lying to 911 at the jump. So why would she say they flipped him over? You know, if I was defense on this case, I'd argue that that slipped out was something that happened earlier before they showed up. That was truthful. It's just the timeline was wrong. Lee Moon, you're saying Snow couldn't give him black eyes and blood down his shirt and jeans and one shoe with 5 DNAs. Yeah, you're telling me at 24 miles an hour you're going to be hit so hard one of your shoes will fly off even though it's tied. You're talking about high vehicle impacts where shoes could fly off. So all right, that's interesting. You just realized, Kay Ritchie, that the judge referred to Jennifer McCabe as Jen McCabe, not Ms. McCabe or even Jennifer McCabe. Very informal for a court proceeding from a judge. Witnesses are also, yeah, they're not supposed to be watching any of this. I think they're all watching it because they're want to see how the case is coming about, how the other witnesses are coming across. May the fourth, you're saying I had this thought about Hank Brennan that he may harbor so much animosity towards the Commonwealth that he's faking he cares. It may just be your brain to not be expect Karen Reed to get 3 not guilty charge votes. I'm just telling you from my experience doing many jury trials, I just cannot see how you can get a conviction on this kind of ash and trash evidence. This many lies upon lies upon lies. A medical examiner can't even declare it a homicide, for crying out loud. 86, you're saying there'd be no trial if they test DNA suitable for comparison on O'Keefe's hoodie and jeans. I don't think any evidence would have stopped them from going forward on this. They need to come up with an explanation. They need to come up with someone to pin it on. Yeah, just a nun. Higgins plow to literally cover tracks. You know, that Ford Edge, maybe that could have been used to, as I've seen people say before, the Ford Edge could have been how they didn't want to have footprints all the way across the yard, and to minimize footprints, could John's body have been put in the car and then brought to that spot, and then they have less feet to go to dump him there. Oh, that's nice. Thanks, Social. Surreal, you're saying you hope the jurors on social media 24/7. So, well, they can't be when they're in the courtroom, but Joe Runnan, you're saying as a judge admitted she's overstepped her authority by saying, I will allow robust cross-examination, meaning she's controlling cross-examination in other areas other than on the law. That's what it sort of looks like to me. So she's trying to inspire, like, hey, you're not losing so bad. I think it's more for PR than anything. She's got to be realizing how many people are saying this thing is such a denial of due process for Karen Reed. You're saying Commonwealth fabricated evidence by changing timelines. Jurors will see that. I sure hope so. If they're younger, I hope they're not the type to just look the other way to folks lying. Will they have a passion for justice, or they just have I don't really care? Will they really study this evidence, or will they just not have any critical thinking skills? RJ Smith, is it customary for a judge not to look at an attorney when they're addressing her directly, especially during important matters she asked him to address? Seems like common decency. She won't look at the defense when they're arguing. She's always doing other stuff, flipping through notebooks and stuff like that. I tell you what, if a judge did that and I was arguing something this critical or anything, I would just stop. I assume the judge isn't listening to me. That's the only way you can get this judge to be forced to look at you. So I don't know why they're not doing something about that. Yeah, GI, a lot of wasted time with the prosecution's ineffective and inefficient way of doing this case. I've heard some others on different clips here and there, different other attorneys talking about this case on YouTube, and I'm just really shocked some of the stuff I'm hearing. But like prosecution's done a good job. They're doing pretty good. And they called all the right witnesses in the right order and all this kind of stuff, presented the right evidence. And I'm just like going, I don't know what to tell you other than the fact that if you hear something like that, I would say you're talking to somebody that hasn't done criminal trials. So if you haven't done criminal trials, you haven't done felony trials, you're going to get a lot of different opinions on this case that can be skewed. Okay, yeah, they should be able to do that. Call Proctor and have him read the appalling text he sent. But who knows? In this case, anything's possible of being blocked. If it's truthful, it's a good chance of it being blocked. So you're separated. You're saying the car or snowplow doesn't explain injuries to the arm, a pattern. Well, they could always say the dog attacked it afterwards, something like that. So anyway, there's any number of scenarios. But yeah, that's definitely a dog attack. It's not anything having to do with Karen's vehicle. Stevie Howell, even Brennan's own witnesses that are watching. That's why they changed the timeline. Probably that in the ARCA report, perhaps. Kate, you're saying you wouldn't even recall any of the witnesses if you're Karen's teams. Don't give them another chance to correct anything. Botched investigation. You always say at the end of a session, please, jurors, do personal research and investigate this trial. Kylie Cosmos, do I think that Hank actually thinks she's guilty? I would say an experienced prosecutor looking at this case, you're not looking at whether she's guilty or not. I think the issue is, can you prove it beyond reasonable doubt? And I think he knows he's got really no chance. And as I've been saying along, he's got no chance unless he keeps out the maximum amount of truth to get that conviction. Island Girl, that's interesting. The Kohlberger judge is making witness sign affidavit saying they did not violate the sequestration order prior to testimony. I've never heard of that before. Wow. That's one way to get control of your court, because you got them on a false statement, perjury statement. Yeah, I would say this judge is an embarrassment to all judges in the United States. Absolutely. I'm just so shocked at what's going on here. I mean, this would be so radically crazy to happen if it wasn't televised, and now we got a televised jury trial, and for this stuff to be going on and on like this, it's like I cannot believe that this is that out in the open. You know what? One of the things that they haven't done is, like we saw in the Adelson case, there's so many criminal cases that they test cell phones and location as the cell phone owner based on tracking the phone through cell phone towers, just like we saw in Charlie Adelson's trial, and then we'll have the same thing for Donna's trial. Where's the cell tower record data for Karen? They never did that. Alex Perkins, is there any chance this Judge can and will be investigated for being so insanely biased? Well, people are making complaints. So whether you give enough specific details for them to actually do something and actually do a investigation on it remains to be seen. Okay, there was one question here. Just regular mom, you're saying can ARCA experts say they deleted texts with clients because of their agency that usually hires them? Like to say it to ensure confidentiality. I think what they said is just fine already. It's their normal course of business. It wasn't a big deal. Only somebody like Hank Brennan would try to make them out to be a some kind of evil character. K9 Lover, you're saying you're not trying to be critical, but there's so much lag time while Carl seems to be looking for questions, so maybe just click out. Well, that's fine. I'm not tying you to the channel at all. You're free to leave at any time. I'm looking for good questions, and the red emojis do help me pick the questions. Tatted, you're saying doesn't the medical examiner not being able to say John's death couldn't be ruled a homicide sort of indicated it wasn't a fight too? Although I do think it was a fight. I don't think the death was intentional. Yeah, I mean, she's basically by undetermined, it could be through natural causes, like maybe slipped and fell or something like that. So I don't know why it would be undetermined, but they cannot describe the manner of death. The cause of death obviously is blunt force trauma. It's back of the head, and with the added factor of hypothermia, which seems to be discredited now through cross-examination. So really, it's a blunt force back of the head. The coldness helps speed it up, but you know what? The lack of frostbite. There was not a lot of details on how long frostbite would take effect. Maybe they're just going to do that through own defense witnesses, but you can't tell me that John O'Keefe laying out there for 5.5 hours wouldn't have some massive amounts of frostbite with his face uncovered, a shoe off, and that thin clothing he had on is for a jacket and a thin t-shirt. Alex Perkins, yeah, the judge absolutely can influence jurors' behavior. I've seen that before. If a judge acts like they don't like the defendant or the defense attorney or both, what we have here, indeed, in this case, then yes, absolutely, that the jurors can pick up on that. However, the conduct that's being performed there by Hank Brennan and this judge will, in my opinion, have a backfiring effect. And I think they'll actually be wanting to root for Karen because they see such a railroad process going on here. Sharma Lily, you're saying you don't have to be a trial junkie like we are to hear about this case. Is everywhere, especially second one. Yeah, I'm not so sure about that. I've not polled other people, but I bet you most people around here in Texas haven't heard about it. So, WV Salt and Pepper, could the court access their phone data? They shouldn't be able to do that. Ms. Diesel, you're saying if Karen were convicted on any charge, would she get credit for time served, even though she's been on bail? No, there's no time served if you've been out on bail. Maybe just the 1 day of it being in process till she bailed out. Yep, Teresa, the judge is acting bored with the defense, not the prosecution. Yep. Spinning her in her chair, twirling her glasses. Yeah, it's like you're not even in a courtroom with a judge not acting like a judge should. You don't have the judicial decorum, temperament. You just don't really feel like you're in a court. Yeah, Dusty Blue, that's what I was saying. It's all a false promise. Yeah, it's true. Full melt. Just stop talking until the judge looks up at you. And as soon as she starts looking down, not paying attention, then stop talking. That'd get her to stop, I think. Maybe not, but that's what I would do. Tweenie, you're asking if many people lose their jobs because of the missteps in this investigation. I don't think so. I think we've seen the last of what Proctor, and maybe they'll give him his job back after this case goes away. I just don't trust that anything in that state. You're so separated, or so you're separated. You're saying young people these days have amazing critical skills. We're in the information age. Yeah, they can get a lot of information, but that's information gathering is different than critical thinking skills. I know one of the viewers sent me an email saying her son in the 40, around a 40-year-old does have critical thinking skills. Her younger ones, 2 boys, are not. Don't have anywhere near the critical thinking skills. And it's just sort of wouldn't have the ability to really sort through stuff like this. So that's interesting comment. Teacup Kraken. I remember being very passionate about justice and had a healthy distrust for authority when I was in my early 20s and still do. Yeah, it depends on what experiences you have in life. Tatted, Duty Ron. Yeah, I've seen that before briefly. Yeah, they're just shocked and appalled that this case made it to trial. They got a lot of experience, credible experience. But I've not reached out to collaborate with anybody. I've had some requests and I have not always responded. JC, I hope the actually younger jurors are more savvy with internet searches and maybe they're even listening to this. Caroline, 4th, you're saying thanks. And your outrage is about what's happening, exactly how locals are feeling. So I guess you're a local there, huh? So if you have all that local outrage, you're telling me none of the 12 will have that kind of outrage. That's what Hank's got to be dreading, significantly dreading. Laura J, you're saying, are you sure they were lawyers? All YouTubers. I watched her Team Reasonable Doubt. Yeah, I'm not going to say any names right now, but I would say also on Court TV, I saw they had a couple of attorneys, including Ehrenberg. I forget his first name. He was a former state attorney down there in Miami. I think he's already left that job, and he's got his own YouTube channel. But he was on Court TV, I think yesterday it was, with some other attorney, and they're saying what a great job the prosecution is doing. That Dave Ehrenberg, yeah, Dave Ehrenberg, and they have they're just going on and on about he's trying a great case, doing great, and all this kind of stuff. And I'm like, going, what's going on? I mean, these guys, Ehrenberg's a criminal prosecutor, but it's I can just tell you this though, because I've been on Court TV before, and I normally am talking about Adelson's, but they've called me up to talk about a case I didn't know anything about with just like an hour of prep time, and I agreed to do it. They sent me a couple of things to look at, and they asked me whether I thought the guy'd be convicted, and I saw a co-defendant testify, and I said, "Yep, looks like the guy's going down." And I didn't have more than like 20 minutes of looking at stuff, and the guy did get convicted. But so I just don't think that Court TV really vets people that really know what's going on in the case, and so they don't filter to see how much you know about the case. They just got to plug in some airtime, and yeah, it looks like Julie Grant went from being pro Karen to anti Karen, and so it's really really strange to see all that happening. Elizabeth Christine, if the defense has to recall witnesses because of the timeline, does that make defense look? And they can mention the Commonwealth as why the recall. Yeah, hey, I think I want to pull that one up about Ehrenberg talking about how great they did. I think you guys need to see that, because that's sort of like a lot of the main media is now turning on Karen. Lee Moom, you're saying, what's my reason I don't answer about the FBI? What about whether they're watching the case or done investigating? I don't think they're done investigating this case at all. I think the corruption there in Massachusetts is so rampant that they probably have a constantly open file, whether it's this case, the Birchmore case. It's all centers around what's going on there in Norfolk. All right, Salem, you're saying you're 45 minutes from Canton and everybody knows 100% free Karen. Okay. If that's the case, then I would say that probably folks weren't really being candid when they got selected for jury duty. How could you not hear about this? Any of you guys that live out there in Massachusetts area and even closer to Canton, probably the more a good barometer it is. But how is it likely that people don't know about this case at all if they got pulled up for jury duty? Does everybody talking about it? Do you guys come across anybody that doesn't know about the case, isn't following it? Thanks, Trinity Girl. Tornadoes. I haven't heard anything about tornadoes down here where we're at near San Antonio, in San Antonio. Mike H. They're trying to stuff Karen into an impossible timeline with her Wi-Fi connected to John's house with some clown. Burgess has made up parent desperate fake report, changed the clock like H.G. Wells. Well, I think that this will actually. The one thing I do when I'm doing a case is that if I know the truth is on my side, no matter what the opposing side throws at me, whether I'm a prosecutor, defense attorney, I just know that I'm going to be able to flip the script on them. If they got a witness against me, I'll actually turn that into witness for me because I'll expose them and their agendas. My theory is when I'm training junior counsel is everybody has an agenda as a witness. Everybody has an agenda. You got to figure out what that agenda is and then figure out how to use that to your advantage to fit your theory of the case. It may be an honest agenda. And maybe I just want to be here to tell you what I know and I got no skin in the game. I'm just telling it like it is because I believe it's my civic duty to tell the truth if I'm called as a witness to a court in my community I live in. Okay. Somebody like Lucky, the snowplow driver, comes to mind. He's that kind of witness. Other witnesses could be like, they could have an agenda to hide the truth because they're implicated in wrongdoing. So you have a full spectrum of motives and agendas. And so the main thing I'm looking at is what are people's motives and what is their agenda when I'm investigating a case and going to try it before a jury or a judge. Sharma Lily, can I explain the definition of reasonable doubt? Because there's a dummy YouTube creator who's saying that everyone is abusing that in this case. Well, the jury instructions I've already talked about. You can look at my deep dive into the jury instructions they have for Massachusetts. It's dating back to like the 1840s. And I do a walkthrough of why it's so outdated and it's really confusing. And it doesn't make any sense to most people listening to it today, to that jury instruction. So they're behind the times, just like they are in so many things there, from my perspective, in Massachusetts compared to other states I'm licensed in, such as Texas. Kristen O'Brien, you're asking how many other pieces of taillight were there? What was there, 20 some pieces that didn't fit from those bigger pieces, smaller fragments? That's what I've said on a comment, Tracy, in Vegas. The least thing this judge could do is pretend to be impartial. Just a none. The protection deflection regarding Proctor speaks volumes. He is key in destroying evidence, tampering with evidence, and planting evidence. Well, I'm not going to say he's guilty of planting evidence, tampering with evidence, or destroying evidence. All I can say is that for him to be this incompetent acting on a case like this is highly, highly suspicious of why he would botch a case this bad. Jessica, you're asking, have you seen the prosecution be allowed to rebut the rebuttal before? Well, the defense, their case in chief is a form of rebuttal to the prosecution's case in chief, and then the prosecutor gets to go again, called rebuttal, so they get to rebut the defense. And the defense could rebut again if they have something to rebut that the prosecution showed. So you try to whittle it down, and normally you don't have the defense doing a rebuttal to the prosecution's rebuttal. But in theory, it's possible if the issues are unresolved and haven't been flushed out properly. Okay, Maya Rodriguez Sorensen, Esquire, you're shocked people normalize Canoni's behavior and rulings. It makes me feel crazy. You've been practicing law 20 years in front of plain judges in your career, it looks like. This is bad. Yeah, it doesn't get any worse than this. I've never seen anybody worse than this. Unbelievable. And the fact that it's all televised, there's no shame, is what's really shocking. To me, the worst part about it. Well, actually, the worst part is what Karen's having to suffer through this with. But like I say, the jury's the equalizer. They're going to settle the score. They got to be fed up. Please keep your chats remarks clean. I don't like seeing profanity or dropping bombs or certain words. So I appreciate that. Trying to keep this courtroom level type conversation. You guys are highly schooled on this case and the evidence or lack thereof. JC's asking if I know any case where troopers planted evidence and the whole police department was indicted and lost. I cannot think of a case where, I'm trying to think, a case where evidence was planted. Can't think of one where I argued it, evidence was planted before. Definitely fabricated false statements. That's like routine. Brit Schick, you're saying even a retired judge from Massachusetts, Carol Erskine, is tweeting that Karen Reed's Sixth Amendment rights being violated by Judge Canoni. Yeah, well, Fifth Amendment rights to due process, among others. Alex, again, can this judge be prosecuted or receive consequences for being so incredibly biased? They don't get prosecuted for that. Thank you. Thanks, honey. Is there a rude comment here? Hoser Mama, no frostbite proves John was not out from 12:30 to 6 o'clock. I hope they pick up on that. They really need to slam that on closing as well. Mr. Monk's understudy, Proctor only requested Android phone data. Wow. Oh, I love MSM. Thanks for your comment here. You just want to say most people where you're from, we live are free Karen Reed and Justice John O'Keefe, even cops, judges as well. Thanks. Well, thanks for you. And I guess, where do you live, though? Are you saying you live in Massachusetts? Lisa, yeah, it is draining on the nerves to see this kind of stuff. I don't like seeing this stuff, and I get upset because whenever somebody's getting railroaded, I just hate seeing that. Even if somebody's guilty, like if I'm a prosecutor, I want the defendant to know you can present your case. I'm going to get you convicted one way or the other. I'm going to hardly ever object. You can present whatever kind of evidence you want because I want it to stick on appeal, and I don't want to deny you your chance to feel like you got a fair trial. If I have to block most of your evidence from coming in, how does that make me look? How do I sleep at night knowing I kept all that evidence out? And if you're guilty, I should be able to prove it. Otherwise, I shouldn't be trying the case. But is it because I'm not good enough in my skills to win the case, and therefore I got to hide the truth? Somebody's complaining. What are they complaining about? I didn't see the complaint, whatever it was. Yes, Jennifer, ranked arm injuries are a huge problem for the state. It points to a dog being involved, not a car. And the dog was really rushed out of there. We never saw or heard from that dog again, right? Why was that dog taken away from there so fast? They said they got rid of it months later that summer, but how do we know? Has that really been run to the ground yet? Denise Sanders, what would happen if the fence let it slip that Arco was hired by the FBI? That could happen. I'm not going to say what could happen, but obviously the judge will get really irate about it. You're violating a court requirement. We have not seen the search results. I don't think that was ever disclosed. Lisa Marie, yeah, the vomit never mentioned on his boxers and all the blood he lost. You think it's in the house? Jamie, can the judge ask her if they're ready to deliberate as Commonwealth arrest? Yeah, I don't think you want to do that, because what if they're all ready to find for the prosecution, not defense? So you don't want to do that. What the judge could do is grant a motion for directed verdict, but that's never going to happen, or never even needs to go to the jury. The judge says there's not enough evidence here to convict. I mean, the judge at trial 1 should definitely convict, thrown out that second-degree murder charge. That would never survive on appeal. This is the most rampant case I've ever seen, full of reversible error. It's just all over the place. Like every day, well, that's another thing. Yeah, I just wonder how much deep dive the feds did. I don't think they look at cell tower data like for Karen and stuff. What if they'd have done cell tower data for Higgins and all his driving around? Chadwick from Canada, you're saying John's fingertips to show frostbite. If the Commonwealth theory was true, I'm Canadian, and all this is very unbelievable, suspicious. 100% agree with you there. J.I., you're saying I don't think it was in our best interest, given the jury that whole speech about their behavior. Mo Roma, you're saying you think she'll influence jurors to go against state with their reduced to the fence. It's so obvious she's acting ugly. Think about the conduct of the lawyers between the prosecution and the defense. To the prosecution, not so much Lally, but Brennan's behavior in court, is the worst I've ever seen in terms of lack of credibility and generating distrust and just generalized generalized, I want to say this as nice as I can, his inability to convey any degree of sincerity and candor and truthfulness, and the way he comes across on redirect, doing all that leading, which the defense has not objected to. I mean, he's basically testifying on his redirect, trying to salvage his witnesses. And the way he beat up on the medical examiner, if they didn't like him before, they really don't like him now. And if they were neutral on him before, or sort of liked him before as a juror, I don't know how that'd be possible. They really should have seen it for what it was when he beat up on cross-examination and just made himself look completely embarrassed. And this doctor, she never flinched. She maintained her guns. She was very brave and courageous. Kel, what concerns you not knowing who can access the jury notes? Yeah, that's a concern of mine too. Christy, thanks. Don't need your money, but if you want to give it to Karen Reed Defense, see you as a registered Ford Edges, check software solved. Well, we know that Brian Albert has a Ford Edge, so that's going to come out. It should come out at this trial. C-Star, yeah, she sometimes doesn't even let them get through with their objection, but you know how fast Brennan says objection, just sort of like Lally did. Yes, Chrissy, I'll have to agree 12 on either guilty or not guilty. It has to be unanimous, not 2/3 vote or anything like that. And yes, it's each of the 3 separate charges. They're all standalone charges. Unlike the first trial where the judge made it sound like they're all, you got to decide them all together. Salt and pepper. Yeah, that's funny you say that, because I was wondering if that would happen, where folks would be shouting it out in the streets. FBI hired ARCA. The jurors probably don't know who ARCA is right now, unless they've been doing research. Mike H., you're saying she makes Judge Ito at the OJ trial look like Supreme Court material. Yeah, she had her head down the whole time. Yeah, it's just, I've never seen a judge act that way either. It's like, I'm not listening. I'm just writing out my opinion, my ruling. Alex, I've already talked about that earlier, but thank you. Joe Running, you're saying if she's convicted, even if overturned on appeal, is it not worrying she's in the hands of the state? Things happen in prison. I'm not sure she'd go to prison. She might be able to keep bail in place while it's on appeal. I'm not sure how they do it in Massachusetts. Okay, Andy, school, thanks for saying this detail. You're saying Karen said she had the rug in the interview with Daniels. She said the investigator saw it was being removed. contact the car company is paying $5,000 a month in climate controlled storage area. So that's interesting. Well, maybe they didn't think they needed it the first trial. Are they going to use it this time around? Yes, Ashley, Lawrence, a lot of the same players in this Birchmore case, and that cover up involving this Canton Police Department. Lisa Lee, what about the fake paperwork they fabricated about Chloe's identity change? Yeah, I thought they could have fleshed that out better at trial. Oops. So I created a marker. Okay. Botched investigations. You're asking, is Garrett Wing still testifying? I can't wait for his visions. I think he is, but of course, the judge is going to try to keep much of his testimony out because it's the truth. Social, you're saying filing a complaint against a judge, Google judicial complaint, 403 error. Wow, that's interesting. I just posted a video on that about 2 weeks ago. And John put a link up on there. And it had to do with the judicial scorecard. Don't know why that would be the case. But there's also a fax number. Just you can look at my YouTube video for that. Law and lit, yes. Frustrating listening to other lawyers discuss it like a normal case. Thank you for expressing your outrage. It helps. How many lawyers are talking about the constitutional violations on a daily basis going on in this case? Have you heard any? I haven't heard a single one. I've never heard a single person mention the Constitution and the reversible error. Other than, I take that back, Judge Erskine mentioned it. Yeah, is Vinny on our side? I've heard that, but I know Julie Grant isn't. Julie, you're saying you saw Ehrenberg say he didn't believe for a minute she's in. Yeah, so how much has he seen of the case? Okay, Amy Bonner, you're saying Rob from Law and Lumber and Ian Runkle saying the other night that we should prepare ourselves for a guilty verdict. They're talking like it could be a good chance. I disagree completely. I 100% agree with you, Amy, and I can tell you that this Ian Runkle guy, I've just seen a few minutes of him before, and I can tell you. Sorry, I need to move on my seat here. I can just tell you he's not an American lawyer. Number one, he's not a criminal lawyer. He's never tried an American felony violent crime case, either as a prosecutor or defense attorney. So if you don't have that kind of experience, you just have a completely different view on things, right? And Rob from Law and Lumber, I've heard of that show. I've never seen it. I don't think. Again, the same thing. I guarantee you, he's done zilch criminal defense work or prosecution work. Yeah, so I would say that from my experience, there's zero chance she gets convicted. Okay. I'm not really going to go into probabilities or other stuff, but I think that there's most likely outcome is not guilty across the board. And otherwise it's going to be a hung jury. And I would say on all three counts. But from my experience, I've not tried cases in Massachusetts, but I've tried cases where people are from all over the country, including from people in the Northeast, and I've not seen any kind of aberrations from doing the right thing. This is an aberration for me, though. I've not dealt with young jurors like we're hearing are on this trial as jury members, but I just cannot believe people with critical thinking skills would fall for this. Alex, while you're from the AU and people in Australia there know about it there? Okay, that's interesting. Tammy Flo, in my opinion, Karen Reed should never done the interviews near 40 years of litigation. I agree with you, Tammy Flo, 100%. Kay Reggie, you're saying you saw one lawyer saying what a terrific job the judge was doing, how fair she was being. I almost fell out of my chair. Yeah, that's what I'm saying. Don't be scared by these other lawyers, okay? They were saying the same thing on Murdo. When I saw Murdo the first week, I was seeing commenters on YouTube just talking about how great the prosecution is doing and all that. And I was like, wow, these guys are bad. They're not trial lawyers, I'll tell you that. So even if they can't predict the outcome, any trial lawyer that says, you don't even have to be a trial lawyer, that says that this judge is being fair is out to lunch. I love MSA. You're saying you live about an hour from Canton. Yes, a lot of people still have not heard about the case around here, but most everybody has. Okay. Interesting. Thank you. Moto 88, you're asking, could the last ARCA witness to testify in the final question, could they include they were hired by the FBI so the jury knows? What could the judge do? Let the truth be out. Seems fair to me. I'm not going to comment on that because I don't want to be accused of inciting somebody to violate a court order. JC, you're saying you feel like mainstream media keeps parroting what the Commonwealth side is, and that it's like they don't dare challenge law enforcement establishment here. Maybe they're afraid of being sued. I mean, state governments don't sue media, so that's not the case there. Maybe individual players or something. I don't know. Not familiar with this Texas mess comment about a case involving Austin Metcalf. Don't know anything about it. Jane Casses, you're saying you're from the Northeast. Lots of free Karen Reed crowd around here. Oh, that's interesting. That's encouraging. Kim in New Hampshire. You live in southern New Hampshire, about 45 minutes from Canton. Everybody knows about this case. This Karen has been set up. Okay, that's encouraging to know. Wow, Haley, you didn't know about this case a few weeks ago. Now you're hooked, almost caught up. Okay. Yep, ARCA, that's going to be the key thing. It's going to help be the final nail in the government's coffin. Yeah, Leah Baker. The 1236, I call that her alibi. What kind of class are you talking about, Little Miss Red Velvet? Eileen Girl, you're saying Leslie's been masterful at flipping witnesses. He's done a great job bringing out a lot of good things. Caroline, fourth, you're saying I've come across people that don't follow it closely, but they always talk about how corruption has been going on here for decades. I think that's why some people aren't shocked by what's happening. Okay, well, hopefully there's folks that have a passion for justice that are on the jury. All right, going to look for a couple more questions. I'm going to call it a night here. Lizzie, you're saying Morrissey Diaz had people on payroll to be trolls on social media, even follow people like Aiden. They post fake photos. Have you heard of that? I've heard of that. I don't know if it's true. Anything's possible. Lizica, can someone please tell me why John was wet when they got to him? I'm an avid snow sports person. Your clothes will get wet from laying on the snow or thawing. Unless it is his body temperature, and even if his body temperature was in the 90s or high 80s when he's out there, is he going to have, because he doesn't have thick clothes on, is that going to make the snow melt when it lands on him? I'm not sure. Auntie Lisa, you're saying, do other states begin with their trial with a hear ye? That seems very antiquated. Yeah, I've never heard that before in any of the courts I've been in America. Hear ye, hear ye. I mean, that's like sort of the old British way of doing things, I guess. I was just thinking the other day, like, this is the land of Paul Revere, American freedom, trying to break off the chains and shackles of tyranny, and yet they revert to it here in Massachusetts after breaking free in the 1770s. All right, with that, I'm going to go ahead and sign off now, and hope to cover again tomorrow night of what happens on Monday, and it's a shorter week, so if you guys want something for me to talk about, then let me shoot me a message. Otherwise, I think what I may do is cover more on Ian Whiffen on probably this coming Friday night, because I never did cover his cross-examination. So I think based on this new changing of Burgess's testimony, I think that might be timely. So yes, thank you for nice comments, and thanks for sorting the justice mission. And thanks to everyone that has helped make this possible, including my mod, Love of Food, and also my brother and wife. So appreciate y'all. Everyone have a good night. Thanks.